The international legal system is broken. Almost everyone can agree with that. To understand why it has come to this, we cannot simply look at one war, one case, and we can't look at it through a partisan lens. We need to see the forces that brought the modern international legal system into being, how that worked, how those forces changed in a way that has turned the system into what it is today. And perhaps just maybe, after gaining that understanding, we can look at the new realities of the world and try to develop a new, better international justice system. At its core, this is a story of two interacting layers in world politics. It is the interaction between the real, objective layer of states' interests and a layer of institutions and norms which try to govern how they work. And when these work in tangent with one another, then the rules gain legitimacy. They are considered worth following, and they in turn help shape the state's interest. They help shape the interaction of the system. They help shape the future. But when these forces become opposed to one another, or when actors simply ignore them, or even worse, when norms and institutions create perverse incentives where states' interests become misaligned with the norms, but can use those institutions to further their own detrimental self-interests. These two layers have to interact with each other in a discursive loop. And when one of those layers changes fundamentally, then there becomes a disconnect. And as the layer of state interest has become disconnected from the international law has become hollow. It has become a legal system disconnected from the needs of both its constituents and those who can enforce it. And in doing so, it becomes easy prey for those who wish to exploit whatever leverage it still has left to advance their own perverse goals. It is easy to weaponize. These laws and treaties were made by mortal men with good, if not perfect, intentions. But they were forged to be both serviceable in promoting the greater good and to take state interests into account. But as the international system has slowly changed, those same laws have now become twisted by knaves to make a trap for fools. This is Causality, the news for symptoms. We provide the diagnosis. On this channel, we take a deep look behind the scenes to see the reasons why world events happen the way they do. In this video, we're going to look at the structural reasons why international law has decayed into what it is today. But to do that, we're going to first take a look at the philosophical foundations and the characteristics needed for any legal system to function. Then we will provide a quick overview of how the modern international legal system came into being and how those characteristics applied to a lesser or greater extent. Then we will take a look at the last few decades and see how these characteristics have fundamentally changed and how this has led to the international legal system to almost becoming first and foremost a tool of propaganda and asymmetric warfare, primarily useful in the court of public opinion. To understand why international legal system is failing, first we understand what a legal system even is and how it works and why it works and what components are needed for it to function. I'm not going to go too deep into the philosophy, but whatever your standpoint on man's base nature, you need to have laws. You need to have people who write the laws. You have to have people who interpret the laws. You have to have someone who enforces the laws. And of course, you need to have people who are within the jurisdiction where those laws hold sway. Whether these laws are formed through a democratic process or simply the king's law, any functioning legal system needs those components, and those components need to work in tandem and reinforce one another. This is perhaps most famously and clearly laid out in the Constitution of the United States, with its separation of powers. One branch, the legislative, one branch, the judicial, one branch, the executive. Those who make the laws, those who interpret the laws, those who enforce the laws. And of course, the body politic. But another characteristic is that those institutions have to be living, continue to be able to be reinterpreted for new laws to be created and for new ways to enforce things to come about. A law that is not living really loses much of its value because there will always be new novel situations and new contexts where the law would need to, at the very least, be reinterpreted to fit the new context, not simply based on the dry letter of the law. It is also important to note that a legal system should ideally be based on a higher understanding of morality, of justice, of fairness. A law in itself is not good or bad. A law is good only insofar as it produces an effect that is good for society, and how society perceives good should inform what laws they make. But the effect of laws is not only to simply be the referee in terms of judging what happened in the system was good or bad, but also the existence of the law helps shape the types of interactions happening within the system, made in order to provide the correct incentive structures for the wanted behaviors to occur. The simplest example of this is that if something is designated as a crime and there is punishment associated with that crime, then an individual will be less likely to commit that crime if they take into account the punishment. But then again, for this to be true, then the individual must think that the punishment will actually happen, that the cost of the punishment is greater than the gain they would get from the crime in any case, and so on and so forth. So the legislative system needs to be built with an understanding of almost the psychology of the body politic, and to take into account their different interests and how the laws can nudge or move those interests into wanted avenues. Another characteristic, while not strictly necessary for a legal system, is usually present in most modern systems, and that is case law. The precedent set by preceding rulings on the different laws can inform how those laws are interpreted in the future. Oftentimes, there is a gap between the law, which is written on paper by the legislator, and all the different ways that that law can be applied in reality. And in most legal systems, there's a certain amount of discretion given to those handing down judgments or deciding cases. And that is why there is an entire profession of lawyers who can argue a case from different sides and try to show how the different sides each have merits under the law. And all of those different pieces form a functional judicial legal system. If there were no laws, then obviously there would be no legal system. But if no one was there to make the laws or have the ability to change the laws, then it would become brittle and disconnected from reality as time goes on. If there was no one to interpret the laws, no one would be able to understand the context of the individual crime and whether it fits or doesn't fit both the letter and the meaning of the law. And if there was no one to enforce the law, then no matter what happens, the incentive structures that the laws were meant to create would not exist. And of course, even if there was a perfect legal system, but no one was inside of it, then it would be functionally irrelevant. Well-crafted legal systems do not try to force a system into a state which goes against its natural tendencies, rather to create mutually beneficial circumstances, and do so in a way which allows for those individual interests to be pursued in a reasonable manner. Laws must both provide the incentive structure, have a plausible level of deterrence, and not constrain the system so much where cooperation is only available through force. This point is key. A legal system's goal is to make sure that the incentive structures of the system promote the desired outcome for society. This is sometimes easier said than done, as there is example after example of laws which create perverse incentives. This is to an extent unavoidable, as often the effect of the law on society cannot actually be fully thought out beforehand and is only discovered upon its release into the wild or decades later. This is an important reason why the legislator has the ability to revisit those laws and to fix an oversight which caused those failings. I hope we've understood that that's how the legal system works. You have the institutions and the laws and the normative power that they try to make, and then you have the entire interest-based system which lies under it. And so if that is how a legal system is supposed to work, let us look at the international legal system. The modern international legal system really formed into a functioning, or at least semi-functioning, state after World War II. And it was that war which informed the rules which were created at the time. And it was the post-war power structure which informed the enforcement regime. The legal system that came about was one in a world dominated by state actors. It was a world which recognized nation states as the main drivers of almost all international relations and conflicts. And so, that is the type of international interaction which was given the vast bulk of thought and restrictions. One of the main purposes was to restrict the amount and the types of combat which would take place between these states. In terms of who was the legislature, well, international law is mainly formed on the basis of treaties signed between mutually recognized states. This was coupled with the creation of the United Nations, which, while also not a legislature, served as kind of the main forum for discussion and in order to organize the different nation states around a topic. Famously, votes among the General Assembly are non-binding, but they did often serve as a basis for further treaty development and also for recommendation to the Security Council, which to there it was largely delegated enforcement. And because it was to the Security Council where enforcement of the laws was supposed to be meted out, they were also given veto power over what laws would be enforced. And this Security Council was based around the victors of World War II. That's how it was on paper, and in real terms, the power structures somewhat supported this. The United States and the USSR each served as sort of the enforcer within their own sphere of influence. Because within each sphere, either power had enough sway to keep the interactions between them and the smaller states within some sort of organized normative system. Of course, between the two spheres, there was always conflict, and each side would constantly do things which were largely considered by the other side as to be against the rules of the international system. And this is where much of the historical complaints about the international system stem, where the powerful could disregard the system when they sought fit. This could be seen, for better or worse, as a perk for the enforcers of the system, because the system really couldn't function without those two superpowers enforcing the system in their spheres. And if they were the ones enforcing it, then obviously no enforcement would work for them. So it was a flaw in the system, but it was kind of a built-in flaw, which without it, it wouldn't have worked. But we should keep this in mind and be careful not to over-romanticize this period, because this wasn't a period where the international legal system was respected by all, and that there was this world of harmony. But it did create a largely functional world, even with its drawbacks. This system did create a framework for cooperation and for competition between different powers outside of the realms of war. And that really shouldn't be underestimated. This system changed dramatically, of course, with the fall of the Soviet Union, because suddenly one of the main enforcers of this system was no more. And this left a huge vacuum on the world stage. At first, it seemed that the United States could simply step in and fill this vacuum and be the global enforcer. And it was in this context of the early 90s that people hailed the end of history, that people hailed the American hegemony, where people hailed this Pax Americana. But the Pax Americana was short-lived, if it ever existed in the first place. One of the reasons for this is that for a system to work, the cost-benefit analysis needs to work for all those involved. The individual interests of the states don't need to perfectly align to the system because there is normative and institutional power which can bridge that gap, but they do need to somewhat align, especially for the enforcer if all of the cost of enforcing the system is placed on one country. It quickly became apparent that the cost-benefit analysis for the United States became a very hard sell. Now, the United States did have some additional advantages and benefits, but the question of whether it reached a level which justified the added cost became almost an existential question for the international legal system. And for more and more of the American public, that cost-based analysis simply wasn't adding up. I go through one of the reasons for this in a different video, where I look at the cost of waging and winning war and how that rose dramatically in the second half of the 20th century and into the 21st century. The cost of going to war around the world in order to enforce international norms simply was too high. The main tools for the United States to enforce these rules were war and trade in the form of sanctions and tariffs. After the cost of war rose, then the US naturally leaned more and more heavily on sanctions as a tool of enforcement. But the sanctions themselves are interesting when looked at the system level. When the first country is placed in sanctions, then they are completely isolated from the global financial and trade system. But with each new country placed outside of that system, the previous countries have new trading partners because they are already sanctioned and outside of the system. What this essentially does is that placing sanctions on a country doesn't remove them from the whole trade system. Rather, it simply creates an additional international trading system outside of the purview of those doing the sanctioning. And with each state added to that list, the punitive effects of those sanctions decreased. Overall, the amount of important actors in the international arena, even covered by the international legal system's jurisdiction, has been constantly shrinking. And one of the main causes of this is the rise of belligerent non-state actors. International law is based on treaties between states, and it is coupled with an international recognition regime, where only recognized states can sign treaties. And this is built on the premise that the entire world can be separated into state jurisdictions, where the nation-state holds primacy. And so as long as all the nation-states sign a treaty, then you would assume that the entire world is covered by that treaty, whether to be enforced in the international arena or by each nation state within their territory. Now, even though this has never been the case, there was a point in time after World War II where, if you squinted, this was mostly true. But what we have seen is the dramatic rise in non-state actors, and they are conducting large-scale military campaigns. In fact, most of the military conflicts of the last 20 years involved non-state actors. But it's important to remember that when I say non-state, a lot of these actors are configured in such a way that in any other period of history, they would have definitely been considered states. Maybe not all of them, but many of them hold territory, exert control over a populace, extract resources from that territory, and exhibit all other hallmarks of a state. But because they are not recognized, they fall out of the realm of the international legal system. They are not subject to the regular laws of the international legal system. And of course, not being recognized has its disadvantages. But we should also not underestimate the amount of advantage this gives them vis-a-vis international law. But what needs to be understood is that this isn't simply something which happened in a vacuum. But one of the reasons this has happened is because of the perverse incentives of the international legal system. So much so that sovereign countries have recognized the utility of non-state actors because they are unrecognized and because they are outside the legal system. And state actors also utilize non-state actors in the form of proxy or gray zone warfare. And in that way, they can conduct warfare outside of the realms of regular international law. And this allows those countries to enjoy the best of both worlds, where they can be within the international system, but they can utilize weapons that fall out of it. And as with anything, if you provide the incentive for something to happen, you will see it happen more and more. And because there is an incentive to be a non-state actor when you want to act belligerently, then this is what is happening more and more. But not only that, because many of these non-state actors are actually in conflict with state actors. And once you have a conflict where there is a set of rules applied to one side but not the other, then you are also providing the incentive structure for non-state actors to conduct themselves in a way which will goad the state actor into doing things which can be perceived as against international law. This means that there is an incentive for non-state actors to engage in crimes against humanity in order to induce their enemies to react in a way which they can then take them to a court of law, which they themselves will never appear before. So what we have done is we have created a system where a large part of the actors in that world system fall outside of its jurisdiction. So this means that there's no more enforcer in the system, and the jurisdiction of the system is diminishing. We need to look at the laws themselves and understand the difference between regular national laws and international laws, because they are different in two key ways. One is that because these laws were formed by treaty, the incentives behind their creation and how they are worded are fundamentally different than those which occur in a regular legislator. Here, states are writing the very laws which they will either uphold or break in the future. And that means that when they are forming the wording of the law, they have an interest to keep the law as vague as possible. Whereas in regular legislators, at least the ideal would be to write a law which works in all cases. With treaty law, the ideal is to make it fit the least common denominator, so it will be signed by the most amount of countries, where it makes ambiguity the goal. And this characteristic is compounded by the fact that there is a minimal amount of case law around international law, because the international system is relatively new, and because of the amount of actors in the system is relatively small, compare the amount of states to the amount of individuals in a country. And the amount of opportunities to bring cases is also relatively small, because states really usually don't want to go to the international court, and so will usually try to find some sort of understanding outside of it, especially when coupled with questions of sovereignty and so forth. And all of this leads to a very, very small amount of case law around laws which were ambiguous to begin with. And so the laws in the international legal system are very thin. They are vague, and they are completely open to interpretation. And the last pillar, which is the judicial, has both its advocates and its detractors. And they have valid points, depending on your political outlook. But what I think most can agree with is that a judicial branch devoid of clear laws, and devoid of any way to enforce those laws, and devoid of a clear jurisdiction, where so much of the actors in the system fall outside of their judgment, has very limited utility. And all of those characteristics together lead to what has been popularly referred to as lawfare, because that is a term for the type of structure which has been created. It is one which has turned the international court system into something which is both cynical and asymmetrical, because once there's no means of enforcement which could possibly deter bad actors, and once the same bad actors see that they can operate outside the legal system while still using that legal system against those who, for normative and moral and philosophical reasons, stay inside of it. Once that is coupled with the fact that the international law is so thin and can be interpreted really any way you please, and once that is coupled with the fact that the international bodies strive to include representatives from across the world, including those very same bad actors, which gives them leverage over the system, it means that the incentives are there to turn the international justice system into an asymmetrical weapon against the countries who most wish to see it succeed. And they can do so while remaining immune from the consequences of that same system. Those who wish can simply disregard the international system whenever they see fit, and use it for lawfare whenever they see fit. Now, the effectiveness of this lawfare has also diminished, but it remains the strongest against the states who still wish for it to succeed. The lack of jurisdiction and the lack of enforcement has made the international system devolve into simply becoming a tool for use in the court of public opinion, simply a tool for the normative world, rather than what could be considered a legal system. Because without enforcement and without jurisdiction, a legal system is not a legal system. And that is how it has become a weapon in the court of public opinion from one actor against the next, instead of being what it actually should be, an arbiter of justice. In a proper, living, legal system, a legislative body could fix these problems, but in the current international system, any change is viewed as an attack on the system as a whole, as it is seen too fragile to allow change. This is something pushed by the very same actors who love the system in the state that it is, both toothless and able to be used as a weapon. But in reality, any system which is too fragile to allow change is not robust enough to serve its purpose. And that means that it is too far gone to salvage without major renovation. And once we understand that, we can understand both where we came from and where we can go in the future. The men and women who put in place the modern international justice system, I do believe, did so with good intentions. But it was built for a world which was aspirational in nature, which never really existed, and has only receded further and further from the truth. While in the world in which it was formed, the power dynamics were there to, even if in a flawed manner, reinforce and to uphold some sort of order in the system. Those power dynamics have faded into the past. And a system of normative power disconnected from the real power dynamics doesn't simply lose all purpose, but something worse. It is there to be twisted and abused by those outside of that normative system against those who still wish for it to succeed. And so this video is a lament on the current state of affairs, but it is also forward thinking. Because if we understand why the system doesn't work today, we can move past simply stating that we either need to throw away the international law or scream louder about international law until everybody follows it. Instead, we can try to think about new ways, a new understanding of how actual power dynamics work in the 21st century to form a system which has a chance of functioning and succeeding in establishing a legal system for the future. The core problem with the international legal system today is that they formed an international legal system which assumed universality. And we have found ourselves in a world which is a far cry from being universal. And the people and the actors who benefit most from that system are the very actors who do not abide by those rules. And those most willing to uphold the values of the systems are the ones who are most injured by those rules and inequality. It is those perverse incentives that most need addressing. How to address that is still an open question. But I think one option is to look at the real ways in which the system is reacting to these changes and perhaps try to lean into those tendencies of the system. Because as I said, the best legal systems reinforce the tendencies of the system and the interests of the actors rather than trying to force it into a shape which it does not want. And so, if the legal system is no longer universal, then maybe the most practical way forward is to simply recognize that fact and not try for a universal system. We have already seen a proliferation of what is called minilateralism, where like-minded countries can sit down and try to understand what is wanted in the system, first and foremost, and then decide what rules they should apply, both to themselves and others. And they will do so with the understanding that it is not universal. And so it should be framed as such. And when you frame it as such, you will automatically allow for higher measures of self-defense, because you know that other countries won't follow it. You will take into account the proliferation of non-state actors because you know they exist, and you know that you need to have a framework for how to deal with them. Because you shouldn't allow it to simply devolve into a strictly realist frame of view where might makes right. Rather, you should sit down and think about what the real norms should be. And in that way, both move forward with a moral option and not be shackled to a system which has been co-opted by those with the worst intentions. Now, minilateralism has detractors where they say that it risks fracturing the international system that exists and that it will throw the system into competing blocks. The truth, however, is that this has already happened. The system is already fractured and it is already separated into different blocks. We only pretend it isn't. This does not mean that you cannot also introduce higher morals into these treaties, but only that you do so with the understanding that you will be dealing with actors who do not bind themselves by those morals. An additional benefit of this is that it removes some of the perverse incentives of those bad actors in the current international justice system. If a large amount of countries were to state that the current international justice system has been weaponized and we are no longer following it, and that we are at the same time replacing it with something moral, not just throwing it away, but actually giving a positive answer to it, which is both just and workable, then the theater of the paper international justice system that exists today will lose some of its strength. And obviously, we don't have to start everything from scratch, and we can take what is good from the old treaties and midwife them in to any new form of international treaties that can be put in place. Because the main problem with the international justice system is the system rather than the laws. If you took those laws, if you were able to form and change those laws to fit the modern day, and analyze where perverse incentives were made, and treat them and make them living once again. And also, once you closed that lawfare asymmetrical loophole and that perverse incentives by the bad actors to keep the international system as is, it opens the door that further down the line, you can create incentive structures to bring more and more into the new systems that you create through fair, equitable, and carefully crafted laws, which should benefit all. And you can try to do so in mind to create a just and moral system. International relations, as with all human societies, is never perfect. And pretending it is can cause much more harm than good. Legal systems are never universal. There will always be bad actors, and the legal system is built to take that into account. That is why there is enforcement. That is why there is punishment. But when the legal system starts being applied only to an ever-shrinking minority of the good actors, then its utility is lost, and it becomes more of a weapon, a tool to be used within the system by one actor against the next, rather than an arbiter of justice that it was supposed to be. Of course, this is just simply a rough sketch, and whenever moving forward into the future, much thought needs to be put in place to solve those perverse incentives of the past, and also make sure that what will be put forth in the future does not create perverse incentives of their own. We need to understand that law matters immensely as a tool for shaping human interaction. But because it is so powerful, we can't simply afford to let it stay hollow. We must strive to move it towards a foundation which looks at the actual power structures and the shared values, and to build something which is functioning, even if that means that the club is smaller. A functioning legal system for 40 countries is better than a fake legal system for 200. We need laws in order to produce a more moral world, but we should never conflate the two. We should always realize that the laws are only as good as we made them, and that they need to be living in order to fix the problems which we create in creating them. Now, this video is more of a foundational piece on the subject of international norms and laws and the entire world system. I've already done a few other videos dealing with different particular aspects on the subject, such as when and how to recognize new states in my video on Somaliland and the Houthis. And I also did a video on international norms through an edge case, how Trump can break some of these international paradigms through tweets. And there will be more videos in this topic to come. And so for that and other, stay tuned. I'm also sure that throughout this video, there were those saying, what about Israel? I have a lot to say about Israel, but I chose to relegate that to another video, which should be coming out shortly, both to keep the central thesis here clean and also to allow me to get into topics in that video, which the very mention of which I'm sure will lead to the video suppression and demonetization by the algorithm. So like, subscribe, and pay close attention to my channel page for that one. If you're new here, feel free to peruse my backlog, where almost all the videos are evergreen, as I use different events as case studies for deeper understandings of how the world works. Follow me on X, find me on Patreon, where I have a free video about my deeper philosophical and theoretical thinking, and as well as bonus videos where I go into my thinking behind making the videos, including this one. And supporting the channel there, as some of you have already done, means the world to me. But perhaps the best thing you could do would be to share this video and other videos with others who you think would enjoy them. And until next time, take care.